the first to know. Nsem-Pii TV.
Yenina yisua de se court case basia na yedi yisua ade nkakra na ehu the judicial system no se de isi etimi adwuma enna no pay okopiem ewo okay FM Kwame Nkrumah kese etena ase na ensema ebeto edwa enra ama Ghana fo nyina eka ho asem 4-1 in favor of Kevin Taylor no eno nenam so ema no eto ne nsafre legal practitioner your friend Kwame, lawyer Kwame Adofo. Na abusuafo lawyer Kwame Adofo analysis bia who be here yi pass ubiti na se dachi bia no se ye ma bench warrant and say the arrest warrant e ba ofia. Onsusu ubiti hu ekwan abefa so na wakopi na wotimi ene police sadom na say the judiciary no etimi edi ensawo so. Ni nyina ene say. O say ase even po the Supreme Court judges no one what disagree and say umukra no munye adwen baako if you say yen convict Kevin Taylor arrest warrant and the man ye de to no say omra na omeyi no ho ano enu ntine ade a the Supreme Court and rather omoye no dangerous precedence na omotimi asate de to ho e kire say sambi no say ye de bench warrant obi fie say e koche na enipa ne pa oma if you say no oma render no powerless enti say police ni ejina courtroom na so the bench warrant obi fie enipa no eti ho akwanya bibiri say wotimi atwena no from because of adea Supreme Court any the NDC as a whole etimi aye no ensam doso na yenkoni nkoti ebusuafo very very educative na also we are odo agenchire ato ase said the beya dachi bino ukwa him na sibi beto a obey ni day ebusuafo yenkoni nkoti
every Supreme Court 4-1 decision a womode ebaye efa yura Kevin Taylor the other court down womu efa ni warrant ho asem arrest warrant ho asem eto say ede be na ne ewiase beche
Kwame na menchia otiefo ne ohefo ne omo a onu unyan ma no mu studio nyina mu biache look 4-1 split just say judges in Ankara they disagreed among themselves. Yes. They disagreed among themselves because are unanimous. That's it.
Okay.
4-1 no. This will be a test. Ruling Nankasa Yazaka. A test for law students. They will be reading it and they will tell us why the one judge did not agree with the others. And it means that as commentators, yes, so likely we are going to disagree.
Na mami musadie bi me tie wo mu ni say decision no a majority of the Apex Court of the Land, the Supreme Court judges no ejina so ni say necessary man kwan e ma ka yetie na sem e wo ho ansa na bi a ya committee to contempt or ya man arrest warrant no ni ade be ni person o mai why na ya man arrest warrant agisi yetie no ansa na man arrest warrant
eno ni asem no eno tina even themselves the judges disagree. You see, no, it means no court can order a warrant to arrest anybody anymore. Since answer was no. It means bench warrant now. One court issue for you to be brought to court is now being rendered nugatory and also useless. Because the position of the law, they say bench warrant. Who if you read the act, the court act near dinner, and the act now, the court can issue bench warrant when you don't come to court. It means come to court, come and tell us why you are not guilty of X, Y, Z.
Summons will be a criminal summons will be a come and show cause.
Yes. So there's nothing wrong with say we issue warrant for you to be arrested. It doesn't mean you are guilty of any offense. See you are convicting. See, this is the distinction. Then it makes sense why you did not hear him before you convicted him. The man has not been convicted. The court wants him to come and then show cause why he should not be convicted for contempt. It's a warrant issue day to day against everybody or anybody who fails to come to court. And they say police officers in a court not asking for bench warrant. It means that the court now cannot grant it.
Oh, sanity.
Was it?
But it will be a dangerous precedent.
It is dangerous. I don't think the judges now they could not agree. The judges themselves could not agree because some of you said, for you to come to court and you say you are not coming, the only remedy available to the court is to issue a warrant for you to be brought, which is what has to be done. Otherwise, you are not coming. It is issue warrant. It doesn't mean say you are guilty of any offense. The court has not said Kevin Taylor is guilty of any offense at all. What the court did, they say, was say a certain video has been brought to the court's attention of somebody insulting the court, and therefore produce him before this court to answer. That's the underlying word, to answer to the question of why he should not be committed for contempt. That is what we call police natural justice and or term pattern. The court.
Law, Mr. Kuta, a Criminal and Other Offences Act procedure, no 1950. Now, what kind section 71 now? Well, it was the issue of warrant of arrest. A warrant may be issued at any time before or after the time appointed in the summons for appearance of the accused, although a summons may have been issued.
Exactly.
Now, two new swap or say a warrant shall not be issued under section 1 unless a complaint or charge has been made on oath. Now, over section 72 no was a summons disobeyed, where the accused does not appear at the time and place appointed in and by the summons, and the accused personal attendance has not been dispensed with under Article 70. The court may issue a warrant to arrest the accused and cause the accused to be brought to before court.
See, in a way, no, the court has now made Act 30 that provision already.
Act 30, yeah.
Useless. But you see, courts are not, they are subservient to Act of Parliament. The law is made by lawmakers, and courts interpret the law. That is the position of the law. And see, in interpreting the law, no, it's always say he needed to be given a hearing before a bench warrant is issued. Meaning that it's a police officer called court. Not say, a year, or person here a year. And so back, many people who know. But when you're not hearing before you get bench warrant. Meanwhile, if you look at this warrant, that's an issue here, or Koko Kwasi and way. What's it? Bring him, he has to be produced before the court to answer. That's what we call natural justice. Audi or term pattern rule now. After was it, come and answer. So, the judge got it wrong. He hasn't convicted Kevin Taylor. So this is going to be a very fierce debate among law students.
Because they say no, we'll be able to see a issue arrest warrant.
Because now the judge, the Supreme Court is give him a hearing first. Give him a woo, no. How do you give him a hearing? I don't think the judges know themselves; they could not agree. That's why I went for one. Because how do you give somebody who is on the run a hearing first?
Now, now, Attorney General no betin yako review. Meanwhile, say no ankon so amba.
Attorney General was the interested party. You see, he was served with the processes as an interested party. He ought to have gone and argued against it. Oh yeah, another one.
I said no, what to me, I'm calling him.
I have grown in your my move. Is it? It means that what by ambassador, you are free, you are above the law.
Not never told me both. Say, I'm not case in a substantive case in one casana. Nurse or banner, you bet you and no, I am moot, and I say,
yes, it's moot. Now he is no longer required to go to any court.
Oh, wow.
To answer anything. Because the warrant has now been struck out. It means that now, no, there's nothing for him to go and answer. Nobody is asking for him anymore. Because, you see, the practicality of this, and I say, it's impossible for you to give somebody a hearing before you should issue a warrant for his arrest. How do you give him a hearing before you issue a warrant for his arrest?
I see. Me, Pacho, meet you.
And also, it's an act of parliament.
Yeah, an act of parliament, yes, sure.
Yes. Hey, where the person fails to come to court, issue a warrant. And the police for any warrant, or the all police warrants will now be set aside. It means that now, no, can operator, the warranty has to be set aside.
Ah! Anybody bet me a usually? Ah! But yes, case be so adjudicated on its own merit.
Matter. When the Supreme Court speaks, they set the law. They have now set the law. Say, for you to even issue a warrant, you need to give the person a hearing. That's what it means. If the OSP warrant no issue, it means that it's now a nullity because he hasn't given Oforiaka a hearing. It is as well judgment. No.
Wow.
Master, we are in for a big storm.
Wow.
All warrants issued before yesterday are now going to be questioned because you did not give the person a hearing. Now, how is that practicable? The practicality of it is that it's not possible for you to give somebody a hearing before you issue a warrant for his arrest. It's your jubilating now when they don't know it's as well. It's a police officer to be mama and because there's a fugitive now, there's no hearing and a court are granted. That is what will happen.
Eti obi betimi arane to the Supreme Court. Ebra ye issue arrest warrant the amano say man hearing answer.
That's what it means. Of course, our authority original so. It original so at the Supreme Court, depending on the panel, we decide to set this ruling aside as wrong. Okay. Supreme Court can change its ruling anytime.
Right.
So what is the mechanism?
Me too, pa.
So the another bench will say no. We got it wrong with this ruling. We are setting aside. Otherwise, now it means that no police officer can go to court and apply for bench warrant. Because if it's granted, it means that it's a nullity because you did not give the person a hearing. That's what it means.
And now accept so a procedure, a choir, as of us.
No. My yes, my year cases are police officers arrested my client, put him in prison, police cells for 13 days. I sued the police, and I quoted this act, and the judge agreed with me. Hey, the purpose of bench warrant is not to go and arrest the person and put the person in prison. No, you arrest him and bring him to the court immediately. It's all that warrant against Kevin Taylor was supposed to do is that he was supposed to arrest it, brought before a court, and the court will discharge it. See, it is there second no back room has 2nd July to say Obama. Almost airport. No, in the court, not court to discharge it, bench warrant. There was no need for even Supreme Court to them to take this case to the Supreme Court.
Okay.
What is the mechanism? Because bench warrant, it doesn't say put him in prison. No. It just says bring him before the court.
Oh, okay.
That's all it means.
Yes, Debbie.
Arrest him and bring him, produce him. It's not a commercial airport. Maybe I'm here. That is here. Academia airport. They had a court. That court are granting the bail. Finish. There was no need to go to Supreme Court. They say what? You say Supreme Court is changing the whole position of the law now. Meaning that now ordinary bench warrant issued to police officers is now a nullity.
Wow.
Yes. and so Supreme Court better assistant position.
I see. Na been more any about wanted, Nebia. You don't pictures about daily.
And the man catch say, can operate a case, Now it means it's analysis. Because the warrant was issued to these people without hearing from Ken Operator. Kevin Taylor's case has now changed the position of the law.
Okay. All right. Now, Lord, Mama Samra, and another landmark a year by any say, Dr. Kwame Adofo and 7 others, so no, Jai Womu, na issue near Sikabia, na a year, my dear, a quadi womu.
He had the way,
Aha. Sikabia, a quadi womu, na yes, womu, and she says, womu 60%. And a man who can see Jawomu. Plea bargaining acts, no. Saying a kafa sadi any day is still knowing.
Nana, there is no law in Ghana that says who 60% to Jao. There's no law. What the Attorney General was saying is a lot of crap.
Why?
There's one court to law. The law, no position of the law, say, even under the Court Act, you can enter into an agreement with the prosecution to provide compensation in lieu of going to prison. But you have to be convicted first. Aha. It means to say, so we are Abayasika, and after through certain circumstances, Abayasika becomes a financial losser. You can enter into an agreement and say, oh, I'll pay X. And if it's acceptable to the state, the state is okay, pay X, but you have to be convicted. It's not available to somebody who is not prepared to be convicted. I don't know. I told SCNO.
Yeah.
He agreed to pay a certain amount, which was accepted. It's more like terms of settlement. But if you fail, it means that you have to. So Ato SCN was convicted first, and he was given an opportunity to pay. Failing to pay, then you go to prison.
Okay.
That is what ended Atuation in prison.
Oh,
It's bueno, there's no law. And I was quite reading it. I was really quite curious to see which law he was going to cite. Once I did law,
one court to authority,
one guy, one court to read. Would they pay you know that kind of
Marty.
And one they say, well, 60% and it's blah, blah, blah.
You can't put something on nothing. So, in absence of any law like that, you know, you then not come by that 60% at the end.
Friend, no, we was always maybe over. He is best. But you see, the truth of the matter, they say, NDC people who were charged, the lawyers that were involved, they happen to be the Attorney General or people working in the Attorney General's former office, the Deputy Attorney General or Deputy Attorney General's former office. Now they find themselves in government. They are going after their former clients, which is what we call conflict of interest. You are not allowed to go after your former clients. So they are in a difficult position. Say, how do I now represent the state against my clients? And until now, I'm finding a way to make all the cases police cases. You know, I'm discontinuing cases. You know? Because you are not allowed to go after your former clients. And Dr. Adofo or the other ones, they were represented by either the Attorney General himself or their office.
You can't go after your former client.
Correct. That is the position of the law. It's like me now, Kwame, we are my client. I cannot in the future go after you.
Oh, be me no be in your case, be and I similar no the pakwa behind.
I'm not allowed.
Oh wow.
That is why. Until they find themselves in a conflict of interest. So they need to find a way to overcome that conflict. And no matter that, that's the truth.
I see. No.
You know, Attorney General. And I will Kwame, we are my former client. Why I'm not allowed to touch your case? Because you've been in a position before. I was confiding in me. I know all your vulnerabilities.
Yes, Sadia, now would be Ebedi evidence okay.
I know all your vulnerabilities. So Pamnocha, no, don't go after your former client.
Wow.
I don't know. One more final one said they are in conflict. And on my head, they drop those charges, finding flimsy excuses which hold no water. Yes, I call you and say. I said, refer those cases are one more than in Sakano. Emma special prosecutor. Because that's what the law says. And this one is important. He's a special prosecutor. He is not on his own. And people are mistaking the special prosecutor independent. No, they are wrong. The act says he can only act when he is authorized by the Attorney General or Parliament. Authorized by the Attorney General or Parliament. But once he has to be challenged.
Baba, you other a subsidiary.